Magruder's American Government. Chapter 20, Civil Liberties, Protecting Individual Rights. Section 1, Due Process of Law. Did you know that DNA evidence has led to the reversal of more than 200 wrongful convictions in recent years? That the use of evidence drawn from the scientific study of body tissues has proved that all of those persons who were convicted and served time in prison for crimes they did not commit? Did you know that there is a strong likelihood that an untold number of innocent persons remain in prison today? As you will soon see, this point alone illustrates the importance of due process of law. What due process means. The Constitution contains two due process clauses. The Fifth Amendment declares that the federal government cannot deprive any person of life, liberty, or property without due process of law. The 14th Amendment places the same restriction on every one of the states, and, very importantly, on their local governments as well. A thorough grasp of the meaning of these provisions is absolutely essential to an understanding of the American concept of civil rights and liberties. It is impossible to define the two due process guarantees in exact and complete terms. The Supreme Court has consistently and purposefully refused to do so. Instead, it has relied on finding the meaning of due process on a case-by-case basis. The Court first described that approach in Davidson v. New Orleans of 1878 as the gradual process of inclusion and exclusion as the cases presented for decision shall require. Fundamentally, however, the Constitution's guarantee of due process means this: in whatever it does, the government must act fairly and in accord with established rules. It may not act unfairly, arbitrarily, or unreasonably. The concept of due process began and developed in English and then in American law as a procedural concept. That is, it first developed as a requirement that government act fairly, use fair procedures, and to enforce law. Fair procedures are of little value, however, if they are used to administer unfair laws. The Supreme Court recognized this fact toward the end of the 19th century. It began to hold that due process requires both the ways in which government acts and the laws under which it acts must be fair. Thus, the Court added the idea of substantive due process to the original notion of procedural due process. In short, procedural due process has to do with the how, the procedure, the method of government action. Substantive due process involves the what, the substance, the policies of government action. Examples of due process. Any number of cases may be used to illustrate these two elements of due process. Take a classic case, Rockin v. California, 1952, to exemplify procedural due process. Rockin was a suspected narcotics dealer. Acting on a tip, 3 Los Angeles County deputy sheriffs went to his rooming house. They forced their way into Rockin's room, found him sitting on a bed, and spotted 2 capsules on a nightstand. When one of the deputies asked, "Whose stuff is this?" Rockin popped the capsules into his mouth. Although all 3 officers jumped him, Rockin managed to swallow the pills. The deputies took Rockin to a hospital where his stomach was pumped. The capsules were recovered and found to contain morphine. The state then prosecuted and convicted Rockin for violating the state's narcotics laws. The Supreme Court unanimously held that the deputies had violated the 14th Amendment's guarantee of procedural due process. Said the court, "This is conduct that shocks the conscience, illegally breaking into the privacy of the petitioner, the struggle to open his mouth and remove what was there, the forcible extraction of his stomach's contents. This course of proceeding by of proceeding by agents of government to obtain evidence is bound to offend even hardened sensibilities. They are methods too close to the rack and the screw. Justice Felix Frankfurter. The case Pierce v. Society of Sisters, 1925, illustrates substantive due process. In 1922, Oregon's voters had adopted a new compulsory school attendance law that required all persons between the ages of 8 and 16 to attend public schools. The law was purposely written to destroy private, especially parochial schools in the state. A Roman Catholic order challenged the law's constitutionality, and the Supreme Court held that the provisions violated the 14th Amendment's Due Process Clause. The court did not find that the state had enforced the law unfairly. Rather, it held that the law itself, in its contents, unreasonably interferes with the liberty of parents to direct the upbringing and education of children under their control. The 14th Amendment and the Bill of Rights. Recall these crucial points from Chapter 19. The provisions of the Bill of Rights apply against the national government only. However, the Supreme Court has held that the 14th Amendment's Due Process Clause includes within its meaning most of the protections set out in the Bill of Rights. In a long series of decisions dating from 1925, the court extended the protections of the Bill of Rights against the states through the 14th Amendment's Due Process Clause. The chart on page 549 lists those amendments that have been incorporated, and with them the 4 provisions of the Bill of Rights that have not been incorporated. The key First Amendment cases were discussed in Chapter 19. Those involving the 4th through the 8th Amendments are treated in sections 2, 3, and 4 of this chapter. The police power. In the federal system, the reserved powers of the states include the broad and important police power. The police power is the authority of each state to act to protect and promote the public health, safety, morals, and general welfare. In other words, it is the power of each state to safeguard the well-being of its people. Police power and civil liberties. The use of the police power often produces conflicts with civil liberty protections. When it does, courts must strike a balance between the needs of society, on the one hand, and of individual freedoms on the other. Any number of cases can be used to illustrate the conflict between police power and individual rights. Take as an example a matter often involved in drunk driving cases. Every state's laws allow the use of one or more tests to determine whether a person arrested and charged with drunk driving was in fact drunk at the time of the incident. Some of those tests are simple, walking a straight line or touching the tip of one's nose, for example. Some are more sophisticated, however, notably the breathalyzer test and the drawing of a blood sample. Does the requirement that a person submit to such test violate his or her rights under the 14th Amendment? Does the test involve an unconstitutional search for and seizure of evidence? Does it amount to forcing a person to testify against himself or herself, unconstitutional compulsory self-incrimination? Or is that requirement a proper exercise of the police power? Time after time, state and federal courts have come down on the side of the police power. They have supported the right of society to protect itself against drunk drivers and rejected the individual rights argument. The leading case in Schmerber v. California, 1966. There, the court found no objection to the situation in which a police officer had directed a doctor to draw blood from a drunk driving suspect. The court emphasized these points. The blood sample was drawn in accord with accepted medical practices. The officer had reasonable grounds to believe that the suspect was drunk. Further, had the officer taken the time necessary to secure a search warrant, a court order authorizing a search, whatever evidence was present could have disappeared from the suspect's system. Protecting the public. Legislators and judges have often found the public's health, safety, morals, and/or welfare to be of overriding importance. For example, to promote health, states can limit the sale of alcoholic beverages and tobacco, make laws to combat pollution, and require the vaccination of school children. 2. To promote safety, states can regulate the carrying of concealed weapons, require the use of seatbelts, and punish drunk drivers. 3. To promote morals, states can regulate gambling and outlaw the sale of obscene material and the practice of prostitution. 4. To promote the general welfare, states can enact compulsory education laws, provide help to the medically needy, and limit the profits of public utilities. Clearly, government cannot use the police power in an unreasonable or unfair way, however. In short, they cannot violate the 14th Amendment's Due Process Clause. The right of privacy. The constitutional guarantees of due process create a right of privacy, the right to be free except in very limited circumstances from unwanted governmental intrusions into one's privacy. Stanley v. Georgia, 1969. It is, in short, the right to be let alone. The Constitution makes no specific mention of the right of privacy, but the Supreme Court declared its existence in Griswold v. Connecticut of 1965. That case centered on a state law that outlawed birth control counseling and prohibited the use of all birth control devices. The court held the law to be a violation of the 14th Amendment's Due Process Clause and noted that the state had no business policing the marital bedroom. Roe v. Wade. The most controversial applications of the right of privacy have come in cases that raise this question: to what extent can a state limit a woman's right to an abortion? The leading case is Roe v. Wade of 1973. There, the Supreme Court struck down a Texas law that made abortion a crime, except when necessary to save the life of the mother. In Roe, the court held that the 14th Amendment's right to privacy encompasses a woman's decision whether or not to terminate her pregnancy. More specifically, the court ruled that 1. In the first trimester of a pregnancy, about 3 months, a state must recognize a woman's right to an abortion. It cannot interfere with medical judgments in that matter during that period. 2. In the second trimester, a state, acting in the interest of the woman who undergo abortions, can make reasonable regulations about how, when, and where abortions can be performed, but cannot prohibit the procedure. 3. In the final trimester, a state, acting to protect the unborn child, can choose to prohibit all abortions except those necessary to preserve the life or health of the mother. Challenges to Roe. In several later cases, the court rejected a number of challenges to its basic holding in Roe. As the composition of the court has changed, however, so has the court's position on abortion. That shift can be seen in the court's decisions in later cases on the matter. In Webster v. Reproductive Health Services, 1989, the court upheld two key parts of a Missouri law. Those provisions prohibit abortion except those that preserve the mother's life or health, 1. In any publicly operated hospital or clinic in that state, and 2. When the mother is 20 or more weeks pregnant and tests show that the fetus is viable, capable of sustaining life outside the mother's body. Two cases in 1990 addressed the issue of minors and abortion. In those cases, the court said that a state may require a minor, 1. To inform at least one parent before she can obtain an abortion, Ohio v. Akron Center for Reproductive Health, and 2. To tell both parents of her plans, except in cases where a judge gives permission for an abortion without parental knowledge, Hodgson v. Minnesota. The court's most important decisions on the issue since Roe v. Wade came in Planned Parenthood of Southeastern Pennsylvania v. Casey in 1992. There, the court announced this rule: a state may place reasonable limits on a woman's right to have an abortion, but these restrictions cannot impose an undue burden on her choice of that procedure. In Casey, the court applied that new standard to Pennsylvania's Abortion Control Act. It upheld several sections of the law, finding that they did not place a substantial obstacle in the path of a woman seeking an abortion from a non-viable fetus. Those provisions, it said, do not impose an undue burden on a woman's choice. The Supreme Court did strike down another key part of the Pennsylvania law in Casey, however. That provision required that a married woman tell her husband of her plan to have an abortion. That requirement, said the court, did indeed amount to an undue burden. Recent cases. The High Court has decided only 2 abortion cases since 1992. Its 5-4 vote in the most recent one effectively overturned its 5-4 decision in the earlier case. Together, the 2 cases underscore the impact that changes in the composition of the court have had on the outcome of cases that come before it. In Gonzalez v. Carhart, 2007, the justices applied Casey's undue burden rule to an act of Congress, the Partial Birth Abortion Ban Act of 2003, and found it constitutional. That statute prohibits a particular method of abortion, a medical procedure that opponents of abortion call partial birth abortion. In fact, that operation has been performed in very few instances. In the earlier case, Stenberg v. Carhart, 2000, the court had applied Casey to strike down a Nebraska law that also banned partial birth abortions, and in language nearly identical to that used by Congress when it passed the federal law in 2003.